Hi everybody, this is trademark attorney Josh Gerben, and I want to talk to you about one of the most underutilized and inexpensive trademark enforcement tools that you can use. And I'm talking about a letter of protest. A letter of protest is something that you can submit if you find somebody else's trademark application that has been filed and you would like to object to it. Now, in most cases, if you see that somebody else has filed a trademark application with the United States Patent and Trademark Office that you think is too close to yours, you are barred from contacting the USPTO to discuss that file. It would be called an ex parte communication, and it's forbidden. In other words, you cannot call the examiner on somebody else's trademark to talk about it and complain about it. You have to go through a formal process. At the USPTO, this formal process is called a letter of protest. So a letter of protest can only be submitted in the initial few months after a trademark application is filed. This is why it's incredibly important to have active monitoring of the federal government's trademark database around your trademark. If you miss the first few months of the application process, you will not be able to submit a letter of protest. So a letter of protest is extremely helpful because what it is you submit a letter and you tell the government, hey, I think that this trademark application is too close to mine. And the examiner who is then reviewing that new trademark application will, in all likelihood, see your letter. And many times, these letters do influence the outcome of the application. In other words, the examiner could then deny this other trademark application based on your trademark rights. And you may say, okay, well, that's nice, but why is this so helpful? Because if the examiner does the denial for you, you do not have to then oppose that trademark application and potentially spend tens of thousands of dollars in an opposition proceeding. So a letter of protest can cause the USPTO to refuse an application that you're worried about and save you from the hassle, cost, and expense of having to file any formal opposition and engage in an adversarial proceeding. Now, letters of protest are not all that complicated, which makes them a great enforcement tool because it means you do not have to spend a lot of money and time to submit one. A typical letter of protest will cost between $1,000 and $1,500 of time if you hire a law firm such as ours to do it. The letter is not supposed to be that long. You're supposed to include a short and plain statement of your concern. You're not supposed to include arguments. So in other words, you're not supposed to tell the examiner, well, I think it's too close to my trademark and give this whole list of reasons as to why. You're just supposed to say, I think it's too close. And then you're supposed to provide some evidence from the marketplace to show how the goods and services in the application that you're protesting might be similar to yours. So let's say that the trademark applications don't have completely overlapping goods and services. You need to show the examiner how they're correlated in the marketplace. Ultimately, letters of protest must be less than 75 pages and many times are significantly less than that. So there you have it. If you're looking for a really good, effective, and efficient, meaning cost-efficient enforcement tool, you should consider actively monitoring the USPTO's trademark database for any similar filings to your trademark, and then filing letters of protest against those applications to hopefully get them denied by the USPTO so you don't have to oppose them yourselves. I hope you found this video interesting. If you have any further questions about letters of protest, please feel free to reach out to us. Just go to gerbenlaw.com, go to the contact page, submit a contact form, and one of our attorneys will get right back to you. Thank you so much. I'll talk to you next time.